Recently, in a big decision, Jammu and Kashmir High Court has decided to quash the detention of MLA from the Doda region of Jammu and Kashmir, Mehraj Malik, who was detained by police under the Public Safety Act. So, in this video, we will try to understand what was the this provision under which he was detained, what is the stand taken by Jammu and Kashmir High Court, and what is the precedent that court has set for the similar incidents in the future. Now, to understand the background of this particular topic, the MLA from the Aam Party, that is Aam Aadmi Party, from Doda was detained under PSA in September 2025. High Court has recently quashed this detention order, and the reason is that court has found that such detention was misuse of the preventive detention law, which police officers and are basically bestowed upon. It also has raised concern about abuse of executive power and at the same time violation of personal liberty. If you look at the background of this particular case, MLA has opposed relocation of a health center, and despite his we can say opposition, the government executive authorities there decided to relocate this. And after this, the MLA was expressing dissent via several different platforms such as social media like Facebook Live. He also sent representatives to the authorities. He met with authorities, and also administration has cited multiple FIRs and DDRs. DDRs is daily diary report, FIR is the first information report. So based on this dissent that MLA has expressed, he was detained because the police authorities believe that his action was affecting public order. And because his action is affecting public order, it becomes pertinent that he should be detained under preventive detention law. Now, as far as the Public Safety Act is concerned, it is a preventive detention law that is applicable in Jammu and Kashmir. Now, under this law, a government servant, especially police officials, are given the power to detain any individual, even without trial, if it is to maintain public order and to ensure security of the state. Now, these are two very, very stringent provisions. A person cannot be detained simply for the normal violation of law and order. It has to have a threat to public order. His action or her action might have a threat to the security of state. Detention can extend up to 12 months on the side, or if arrest is made for the public order provision, and even can extend up to 2 years. You can imagine 24 months if the action of individual might directly challenge and threaten the security of state as such. Now, as far as the legal provision is concerned, Section 8 of the Public Safety Act clearly states the government can detain a person if actions are prejudicial to the public order, threat to the security of union territory. In the particular case of Jammu and Kashmir, executive has wide discretionary power. Now, why we are talking about discretionary power? Because there is no particular what you can call as guidelines based on which a decision can be taken. It completely it's dependent upon the discretion power enjoyed by the authorities there. No immediate judicial trial is required. That means person need not be immediately presented to the authorities, judicial authorities or court. He can be detained, as we have discussed, for 12 months to 24 months as such. Preventive detention law versus criminal law. What is the major differences? So the first biggest difference is preventive detention can be exercised as a preemptive action. That means even if person has not committed a crime, but his action point to that he might commit crime in the future, he might threaten the security of a state, his actions might cause disturbance to the large public order, the person can be arrested. Criminal law, on the other hand, is a post facto law. That means it only kicks in if person has already committed an offense and then he has to be punished for his crimes. Now, in this regard, the High Court of Jammu and Kashmir has observed that Public Safety Act cannot replace normal criminal law. That means generally as a rule of law, criminal law has to be followed. Public Safety Act has to be brought in only in the rare circumstances. If FIRs exist, prosecution should follow. PSA should be used only when ordinary law becomes insufficient to deal with this particular case. And also, High Court has stated that the existence of DDRs, it is not equivalent to FIRs. That is not a valid ground on the basis of which AAP MLA was detained here. Now, what are the constitutional safeguards that High Court has taken into consideration? So, first is Article 21, which provides every person in India with the right to life and liberty. Every citizen of India enjoys right to life and liberty. That also includes not being detained or be put in jail. Article 22(5), that is rights of detainee, is clearly mentioned here. Even if a person is detained, he has bestowed upon with certain rights. These are that he must be informed of grounds of detention. That police officer who is detaining it, he must communicate to him that on what charges, on what grounds he is being detained. Right to make representation. It should be as quick as possible, as soon as possible, and court noted that if person is detained but these rights of detainee under article 22.5 is not granted, that is failure to provide evidences or videos, it clearly and clear cut violates the right of the individual as such. Now the question was related to whether the action of the APLA was was more about law and order disturbances or whether it was about public order disturbances. So the court has given a concept, Supreme Court when talked about in the earlier cases, has stated that law and order case is when action is by individual and that can be considered as a local issue. Its impact can be experienced by some individuals in the locality as such. Public order disturbance we can only say when it affects society at large, while security of state is the highest level threat that has to be analyzed on a case to case basis. PSA is only applicable if public disorder disrupts normal life. That means entire society's life is disrupted to a large extent because of the action of individual, and court this stated that in this particular case the action of MLA from Doda was more of law and order issue. His action were disturbing law and order. It was more of localized issue. It did not have any impact on public order as such, disturbances of society at large. And that's why detention under PSA court has found that cannot be justified. DDRs cannot justify detention. There was no real threat as clearly seen from the action of MLA that could have in future even disrupted and caused problems in maintenance of public order. And thus authorities has used this law to detain the individual without applying mind. So this is what High Court has ruled in this case. Now, key principle is preventive detention must be used sparingly. That is what in the earlier judgments of high courts and even Supreme Courts, we have seen this stance being reiterated, and it cannot be used as a tool to suppress dissent, which seems to be a case in this particular incident as such. And also, while talking about it, the High Court of Jammu and Kashmir has looked at the precedent of other High Court from India, where it was said that the law can be considered as a concentric circle. In the first circle sits law and order. In the second smaller circle sits public order, and the smallest circle is where you have the security of state. So most of cases basically are disturbance in the law and order. Public order related provisions should be applied sparingly, and the security of a state, if someone is threatening it, it should be judged with a proper application of mind. Now, based on this entire judgment, if we have to take key takeaways, we can say that definitely Public Safety Act is a powerful but controversial law. Why powerful? Because it gives right to the authorities that anyone can be detained even preemptively and can be put in detention for a 12-month and at max to 24-month without any kind of what you can call as without any kind of right. That person has to be immediately sent to the judicial custody or judicial authorities as such. It requires strict safeguard to prevent misuse as well, and judiciary acts as a check on executive power. And the example of this is what we have seen in this particular judgment. In conclusion, we can say that in the particular case of Doda MLA being detained is clearly we can say is violation of the civil liberties, and that's why how important the civil liberty rights granted to us under Article 21 is. That is something that court has also talked about. There is a need for clear distinction between law and order versus public order. Why? Because earlier we have discussed that whether action by individual is threat to law and order or public order, it is discretionary. It is not decided by any proper we can say guidelines, proper SOPs. It is based on the discretion of the authorities. And also we need to have a balance between security and fundamental rights. So security of state is something, obviously that is something we cannot take lightly if any threat emerges, but at the same time we have to ensure that fundamental rights of individuals are not violated, and the use of such law, which is very strict law, which is very harsh law, should be done with a proper application of mind and should be not a rule but should be done in a sparing manner. That's all for this particular video. Please share with fellow aspirants as a subscribe channel for more content. Thank you very much.